day two. Again, a few logistical issues. If people, I hope, would remember to silence your cell phones. I see we have fewer people who might have cell phones. And once again, we have provided water for petitioners, the applicant, the staff. So feel free, if you don't have a bottle of water near you, grab one. If there's some down there, there should be plenty down there. I think our plan today, just say a few words about that. We're going to begin with, I think it's probably Mr. Lightly will be presenting the applicant's views on some generic issues of standing, to which all the petitioners are free to respond, but if you agreed on one lead, that would be terrific, probably more efficient, but that's up to you. We'll get to that. After that, we will have questions from the board. I think all of us feel that a lot of our questions were answered yesterday, even though that was not the primary purpose of yesterday. We really got a lot of questions in, we got a lot of answers. So we are hopeful that this will be a relatively short session today. We'll certainly take a break, but our thinking is that if there's an excellent chance of finishing in the morning, we'll take whatever time we need to finish and have lunch afterwards. And we might not even get that close to noon. We'll just have to see how it goes. But no guarantees, but I think we're all quite hopeful we will finish this morning. So with that, Mr. Lightly, would you like to begin? Or Mr. Matthews?
Judge Robertson, if I might, I just wanted to make a correction for the record.
Sorry.
Tim Matthews for Interim Storage Partners. I just wanted to make a correction in the record. I erroneously indicated yesterday with respect to Baskin's motion related to the Nuclear Waste Policy Act. I made a point about failure of service, and that's incorrect. It was, the initial motion was not, in fact, served on Interim Storage Partners, but they did resubmit the motion 2 weeks later, and it was served on us, and we did not argue failure of service in the response.
Great. Thank you. Thank you.
Good morning, Your Honors. Ryan Laney for IS. I know we're here to talk about standing first thing, and I think it may be helpful to begin with a brief discussion, a high-level overview of the three types of standing, just to set the stage for what we're going to talk about today. There are three types of standing in NRC proceedings. On one end of the spectrum is traditional standing, and there is also, on the other end of the spectrum, proximity standing in reactor licensing cases. And then in the middle, between them, is the hybrid of proximity plus standing that applies to this proceeding. As to traditional standing, it would be helpful to think of these three types in terms of a map. Visualize a map. For traditional standing, a petitioner needs to show that a harm would accrue at a particular point on a map, and that they have interests at that point on a map. In the reactor proximity presumption, however, the Commission has generically determined that the potential for consequences is assumed at a radius of 50 miles, and the only demonstration a petitioner need make is that they have an interest within that 50-mile radius. But with the hybrid proximity plus standing, a petitioner needs to show that there will be an obvious potential for off-site consequences at a radius circle, not a point circle, as in traditional standing. So when we talk about the three different types of standing, the proximity plus is a presumption. There still must be a showing of harm in proximity plus, unlike reactor standings, where the Commission has generically determined that there is an obvious potential and it exists at a radius of 50 miles. So there are really two showings that we're talking about here that the petitioner needs to meet with proximity plus. That is, that there is an obvious potential for off-site harm, and what the radius is for that potential. And none of the petitioners in this proceeding have made either of those demonstrations. The commission has generically determined as well that the type of activity for which ISP is seeking a license falls into a category of ultra-safe activities that do not require off-site emergency planning because the potential for off-site harm is not plausible. This type of proceeding is different from other ISFC or Part 72 applications that may involve at-reactor ISFCs, spent fuel storage pools, or other applications that have fuel handling operations. And the reason is that the risk profiles are very different in those types of proceedings. We discussed this a bit in our pleadings, and it really goes back to the Part 72 emergency planning rulemaking where the commission made that distinction. They discussed at-reactor ISFCs, wet fuel handling operations, and they recognized that the risk profile is significantly different for the type of activity that ISB is seeking a license for here, and that is dry storage away from reactor with no fuel handling operations. So the risk profile is very different here and falls into a category of activities that the commission is generically determined to be ultra-safe and to not require off-site emergency planning.
But isn't there a difference, Mr. Lightly, beyond what is a reasonable requirement for emergency planning, which is something I assume involves a lot of effort and cost, and a standard for whether somebody who lives across the street from a facility is allowed to at least file a petition. Put aside the commission's views about strict standards on contentions, but on standing, hasn't the commission said, I hate to use the word lenient, we should be less strict than when it comes to contention admissibility, that we should be open and welcoming to petitions by people who at least perceive a risk, even if, in your view, it's not really a substantial risk. What's your response to that?
Well, I think that's absolutely right. The commission has acknowledged that, that there is some leniency in standing. However, it is a statutory requirement, Section 189A of the Atomic Energy Act, to demonstrate an actual interest that may be affected by the proceeding. The perception of an interest that may be affected wouldn't satisfy the statute. In proximity plus presumption, though, that is a commission policy to create a shortcut to show standing. And so when we're talking about meeting the requirements that the commission has established to invoke that shortcut, what we're talking about is a very wide gap between the commission's scientific determination that there is no plausible possibility of off-site harm, right? There's no plausible possibility of it, and the proximity plus presumption requirement of a showing of an obvious potential for off-site consequences. There's an enormous gap between an obvious potential and a scientific determination that there is no plausible possibility of off-site radiological consequences. And so I think that gap is what we're really talking about here. The gap between the commission's scientific determination and the standard in the commission policy that you have to jump over that hurdle to get the shortcut. Now this has nothing to do with traditional standing. Petitioners could make their own arguments in traditional standing states. But this is the obligation that the commission has imposed for the privilege of invoking the shortcut.
But understood, the commission also at the same time cautions boards that we should not conflate merits determinations with standing determinations. Granted, the commission has created a shortcut today, but in applying that shortcut, aren't you urging us to basically come back to your contentions and say that and examine whether there is a plausible possibility of a release of radioactivity from these casks when, let us say, intuitively or obviously the petitioners feel there could be And isn't that enough for them to at least get in the door to argue the admissibility of their contention?
In a reactor licensing proceeding, I would say yes. But because the commission has imposed the additional hurdle in proximity plus of a demonstration of the obvious potential and the basis for the radius to be used, I think the board's decision in LVP 19.4 on the AFES standing is instructive here. The board, I take it, had some difficulty in
It was a
determining
non-decision, as I recall.
Correct, in determining the radius to be used. And that's because none of the petitioners provided any basis for a determination that there is a radius at which harm could accrue. And I think the absence of that demonstration is exactly what we have in the petitions here. None of the petitioners have demonstrated an obvious potential for off-site consequences at any particular radius. If we look back to the emergency planning rulemaking, a commenter in that rulemaking suggested that the commission adopt a very small, compact, 1 to 5 mile radius for off-site emergency planning. The commission rejected even that. So if there is some plausible possibility of off-site harm, it resides somewhere short of a mile from the site. The case law that many of the petitioners cited were 17 miles in other proceedings, again, was wet fuel storage at reactor operations. We're talking about exposed fuel.
What about the DC Circuit decision in the NAI case where there's 18 miles, I believe, and that was not wet storage, and that was Yucca Mountain.
Yes, Yucca Mountain, a million years of storage, I believe was the licensing action there. Again, I think that's very different. If I recall as well, the Yucca proceeding did involve some fuel handling operations next to the site as well. And so, again, very different risk profiles, very different licensing actions. And as the commission has stated with proximity plus, the determination must be case by case. You have to take into account the specific facts of the licensing action that's being proposed. And so I think that case is inapplicable here. Again, what the petitioners have alleged in the petitions is that the quantity of the proposed storage alone is enough to demonstrate an obvious potential. And that's just not the case. As the commission stated in the Schofield Barracks case in CLI 10-20, even an extraordinary volume, to quote the commission, extraordinary volume is not enough to demonstrate an obvious potential for off-site consequences. You must go an additional step to show that there's some plausible mechanism for off-site release. And the commission, again, has also made clear in CLI 0413 that, quote, conclusory allegations about potential radiological harm, end quote, are insufficient to satisfy that verdict. The petitions here do not offer anything other than conclusory allegations about potential radiological harm. And it's just not enough. There must be some demonstration of plausibility. And the petitions don't meet that burden. Again, this is a type of activity that falls into what the commission has determined to be an ultra-safe category of activity. Very different than wet storage, fresh fuel, on-site operation.
I'm a little concerned about the practical consequences of the standard you are proposing. You hint at the possibility that maybe if someone lived within a mile of the proposed, they wouldn't necessarily object, or at least object strenuously. But I mean, who would have standing? I suppose if you were building this on top of a Native American burial ground, it would have standing. But who in your view would have standing to challenge the movement of much of the nation's nuclear waste to a lot across the street? Who would have standing under your theory?
Sure. I would note that all we're talking about here is the privilege of invoking the shortcut to standing for proximity plus presumption. We're not talking about any determination applicable to traditional standing. So the avenue of traditional standing is wide open. Commission's determination doesn't necessarily weigh on it. And so what I would say is it's possible that in terms of radiological harm, perhaps someone with on-site interests could raise a standing claim. Workers at the site, contractors, businesses with equipment that's leased at the site, whatever the case may be, on-site radiological harm has not been carved out by the Commission's generic determination. And second, off-site non-radiological harm has not been precluded by the Commission's generic determination. And so I think the only thing that's carved out is this narrow area of off-site radiological harm being used to invoke the privilege of the shortcut in proximity plus. And I think that's a fairly narrow area that's been precluded by the scientific determination that the Commission has adopted. The fact that the petitioners here haven't sought any other grounds for standing here, even though the conclusion, applying the law correctly, may seem harsh, that's not a basis to abandon the law here. The alternative, however, is discretionary standing. Discretionary standing is permitted under 2.309E, where petitioners have not met the legal requirements for standing. The board at their discretion could admit petitioners with standing.
Has the commission ever sustained the finding of discretionary standing?
That I don't know the answer to.
I don't either, but it hasn't happened often.
I'm not familiar. But it is codified in the regulations. 2.309E makes it explicit, and there are criteria that must be satisfied, such as a demonstration in the initial petitions that petitioners would create a meaningful contribution to the proceeding, and so forth. But again, here, none of the petitioners attempted to make that demonstration. That was their choice to do so. It was their choice not to address those criteria as a backup to their standing argument. And again, even though the outcome may seem harsh, it's not a basis to abandon the legal requirements for standing, because it is, again, in the Atomic Energy Act. Petitioners must demonstrate an interest that may be affected by the proceeding, and the Commission has wide latitude to set the criteria for who may invoke the shortcut. We would urge the board to consider those criteria.
Just curiosity, could the proximity plus criteria be used based upon an environmental impact? I mean, you've addressed safety.
Yes. My understanding of the proximity plus presumption is that the shortcut is for demonstration of an obvious potential of off-site radiological consequences. Certainly in a traditional standing showing, something within the realm of NEPA could be a basis for standing, but I'm not aware of any cases where a NEPA allegation has been allowed as a basis for a proximity plus shortcut implication.
And in your case, if I remember correctly, all of your environmental impacts were either small or non-existent, so they would have to actually challenge that finding as well.
Yes. For example, let's say that a petitioner alleged that construction dust had not been adequately analyzed in the environmental report, and showed that they had an interest that was within a radius where that construction dust could cause them harm. I think that may be a scenario where you've got a non-radiological off-site consequence that would be sufficient for showing of standing.
But the petitioners haven't done that.
But the petitioners have not done that yet.
Thank you.
Judge Curran, any questions? Thank you, Mr. Larry. How have petitioners decided they wish to proceed? Individually or with a single presentation? Ms. Curran?
Good morning.
Good morning.
The petitioners have decided we're each going to proceed on our own because we each have made different standing arguments, and I'm sure we won't be completely repetitive, but or not
Well,
to designate one person.
This argument affects all of you, and so that's fine. I do urge all of you to try to be crisp and efficient as you can.
Who said no? With all due respect, I'd like to correct a couple of things that Mr. White said. First, Beyond Nuclear did claim traditional standing. It's in our hearing request. We claim traditional standing through the frequent contacts of people of our standing declarants with transportation here, transportation routes near the railroad yards where spent fuel would be stored. So that is something that was in our hearing request. We
We
also
can't hear very much. Sorry.
Oh, sure.
I think if you slightly move that mic,
Right, it's okay.
much better.
Yeah.
So I will repeat and say that we did claim traditional standing. It is in our hearing request. We also would argue to you that NEI versus EPA is, to a degree, a traditional standing case because the court talked about how the effects could harm the standing declarant in that case. And I would also say that the distinction that Mr. Lighty makes between the NEI case and our case is not a distinction of importance here, that there is, as in the Yucca Mountain repository case, there is also a potential here for CAS to remain for a lengthy period at the site, and there is a potential for them to release radioactivity. And just, to get back to the central point here, and I think it gets to your question, Judge Ryerson, of when would anybody have standing to participate in a case like this? If the basic presumption for assess and used by the NRC to assess standing is that CAS will be operated in complete conformance with the regulations for only the license term that is being sought here, and that everything will go well, then no one will ever have standing. But the issue is that, as in all aspects of life, there are risks. There are risks that CAS will not maintain their integrity. There are risks that there will be an accident. There is the potential, but the cladding inside the spent fuel storage cask is flammable. We haven't even talked about the risk of an attack on a spent fuel storage cask. We know that in this circuit, that can't be addressed in a NEPA case. But you can't rule that out for purposes of standing, because standing is a broader inquiry and it is a much different test. And with that, I would like to get to the relevance of the emergency planning rule that ISP relies on. The commission in that case did not say that the potential for off-site harm is not plausible. They just didn't say that. They said there was not a significant potential for off-site harm in the context of emergency planning, which is an immediate response to an accident. It doesn't say anything at all about what if an accident resulted in longer-term release of radioactivity that didn't rise to the level of an evacuation, but that contaminated the environment. They didn't address that, and that is certainly a relevant concern for purposes of standing. The standard for the proximity flood presumption is whether there's an obvious potential for off-site consequences. It doesn't mean that it has to be significant or likely. It's an obvious potential. And if you look at there's a case decided by the licensing board in 1996, Yankee Atomic Electric Company, LBP 96-2, 43 NRC 61, which says that that the licensing board said, we don't find ourselves in a position at this threshold stage to rule out as a matter of certainty the existence of a reasonable possibility that, in that case, decommissioning might have an adverse impact to petitioners' members who live nearby or recreate nearby. So we're talking about whether the NRC can rule out the potential for off-site consequences. And we think that with a facility that would store in one single place half of the existing inventory of spent fuel in the United States, 40,000 metric tons, you cannot rule out the potential that in such a large quantity of spent fuel storage casks, you may have an accidental release. I think we dealt with this in our reply to the oppositions to our hearing request, but the Schofield Barracks case is not helpful in this case because Schofield Barracks dealt with low-level radioactive material that was widely dispersed over a large area. It's just not what we're talking about here. We're talking about a highly concentrated collection of highly radioactive spent fuel, not comparable at all. And I just, in closing, I want to read you a quotation from the emergency planning rule that I think is helpful. The citation to the emergency planning rule is 61 Federal Register 32430, and this is at page 32439. It says, and this is in the context of emergency planning, at this age, spent fuel has a heat generation rate that is too low to cause significant particulate dispersal in the unlikely event of a cask confinement boundary failure. Therefore, the consequences of worst-case accidents involving an asphyxia located on a reactor site will be significantly less than those accidents involving the reactor. So they're looking at the unlikely event of a cask confinement boundary failure. They don't rule it out, they just say it's unlikely. So for purposes of this proceeding at this stage, we don't think that you have the basis to rule out an accident that would involve a radiological release from a cask, and therefore you would not have a basis for denying your standing. Thank you.
Any questions? Thank you, Ms. Curran. Mr. Taylor.
Thank you. So it's an advantage to follow Ms. Curran's argument. I don't have to say very much. The Sierra Club has two bases for standing in this case. One is we have two declarants who live in Eunice, 6 miles from the site. I might just note parenthetically that ISP has objected to Rose Gardner because apparently she also signed a declaration for beyond nuclear. I don't know that the commission has specifically said that a declarant cannot be representative of two organizations. But in any event, we have a declaration from Shirley Henson, who also lives in Eunice. So I think that's probably a non-existent question in terms of standing. But so we have the standing based on residence within 6 miles of the site. We also have standing based on proximity to the transportation route. Again, in Eunice, and we also have the declarations from the Dyer family in Hobbs. And if you recall, one of the maps Mr. Lodge showed yesterday showed definitely that there is a transportation route north and south that goes through Hobbs and Eunice, and there's a little spur that goes directly to the proposed waste site. So that's definitely going to be a transportation route. The commission has made it clear that proximity plus standing applies to waste sites or similar projects that are not reactors, where standing was accorded to petitioners up to 17 or 18 miles away. And I guess I find it a little bit ironic that the petitioners yesterday were not required, we were asked to distinguish this case from the Holtec decision that this board rendered a few months ago. But apparently, the ISP is not being asked to distinguish the standing issue between the two, because clearly the standing issues are the same here, and the board accorded standing, noting these cases that would allow standing for 17 or so miles away. And I haven't heard ISP make any argument about distinguishing this board's decision in Holtec from Sachs in this case. In terms of a plausible harm or plausible connection between this project and the standing allegations of the declarants, the declarants specifically identified what their concerns were, why they had the concerns, and in our petition, we also referred to our contention concerning the safety and environmental impacts that we felt would be created by this project. And as Judge Larson noted a little bit ago, the standard for admissibility of contentions is not the same as the standard for finding standing. So the fact that we have at least presented some plausible concern that these declarants would have based on our contentions, I think that is something the board can and should consider. So based on all the cases Ms. Curran mentioned and the cases that are in our petition and our response, our reply, we believe that we do have standing just as we have standing in the Holtec case.
Any questions? Dr. Arnold?
No question.
Mr. Gross?
Thank you.
Thank you, Mr. Carroll. Mr. Lodge?
Thank you, good morning. In the interest of crisp efficiency, I would like to indicate that the joint petitioners adopt the arguments that were advanced by Beyond Nuclear's attorneys. I'd like to supplement that, however, with a number of points. We believe, and I'd just like to remind the board of the major distinction between most of the joint petitioners and other putative interveners here, that being the fact that we're talking about grassroots organizations with members who have provided declarations of proximity to what we believe are known and or readily identifiable rail routes and other transport routes to en route to WCS, Texas. We believe that there's an obvious potential for off-site radiological harm that is admitted in the environmental report. There's discussion at tables 418, 4-18, 19, and 20 within the environmental report of radiation emissions from routine incident-free transport. There's also the return to sender, what I call the return to sender policy enunciated by the applicant here, whereby if contaminated, leaking, troublesome canisters or casks arrive, they will in some sense, I guess, be patched up, remediated enough to put back on the road home. They will be returned. So there will be a knowing send back of spent nuclear fuel. We also would point out that the tab reloading issue, which is gapingly unresolved for purposes of consideration of this application, certainly raises some interesting questions. As I sat listening to the WCS presentation, it occurred to me that by denying any possibility, by claiming that this would be a perfectly executed business plan for generations, you get to knock all of the interveners out because they just don't have enough to show for standing. As Mr. Ryerson indicated, Judge, a while ago, I have to agree with what you were saying. I think there's an enormous attempt to conflate merits with the much different and lower thresholds for standing because of the fact that they don't get into, that this explains the preposterous notion that in the 2120s will be the first appearance of the dry transfer system. It explains why there would be a return to sender policy, because outwardly the applicant maintains that this is all low risk, effectively a perfect conceived idea. What could possibly go wrong? So you have several different modes of potential offsite consequences. You have a given of offsite radiological consequences to and from the facility. And I'd like to discuss the traditional standing that we believe the joint petitioners, not just Ms. Gardner-Aguilar, but the people I consider to be at considerably further distances away from the facility along the routes. As I pointed out, Patricia Mona Bolton, Van Horn, Texas, works 100 feet away from the only apparent east-west rail line between El Paso and Monahans. She lives a block away from that same rail. We have people who have demonstrated that they are certainly within the zone where one might conceive of routine, incident-free transport radiation emissions. The WCS claims that effectively we have only raised a generalized grievance. We believe that that's quite incorrect. The term generalized grievance doesn't just refer to the number of people who are allegedly injured, it refers to the diffuse abstract nature of the injury itself. So just because, let's say, hundreds, thousands, or most likely millions of people live proximate enough to probable rail corridors that they will be subjected involuntarily to radiation emissions, just because there's millions doesn't mean that if a handful of them file declarations that they have identified this as a concern, if they are actually following in the path of the adjudicated fact from the Savannah River case, the Mox Fuel Facility case, that noted the possibility of incidental emissions of radiation, incidental exposures. The fact that a few people are raising it and are invoking a statutory procedure that is purported to protect public health and safety is significant. It takes this out of the class of dismissible, generalized grievances. We also point out that the logic of the Savannah River case. I call it the Duke, Coachman, and Stone Webster case, but the Savannah Mox fuel case is sort of interesting on its facts. We're talking about finished fuel being delivered to two recipient reactors, a total of 550 contemplated shipments, and spent nuclear fuel presumably contains a good many more radiological poisons, which are in a less stable circumstance than MOX fuel. The fact that a mere 550 shipments was contemplated in the Savannah River case is sort of glaring in the shadow of potentially tens of thousands of shipments to the Texas site. But the logic of that licensing panel, which unfortunately this panel considers to be an outlier type of decision, but the logic of it lays out very well the same logic that we propose be applied to our situation as joint petitioners. Quote, as the intervention petitions indicate, incident-free shipping of plutonium provides a dose of ionizing radiation, albeit small, to anyone next to the transport vehicle, and a minor exposure to radiation, even when within regulatory limits, is sufficient to state an injury in fact. And that cites to the Yankee Atomic Electric Company case. Quote, further, the asserted harm here, injury to the health and safety of petitioners' members from ionizing radiation, is clearly encompassed by the health and safety interests protected by the Atomic Energy Act. Nor is there any doubt that the injury alleged by the petitioner's members is fairly traceable to the production and subsequent manufacture and shipping of MOX fuel. Because the transport of MOX fuel to the mission reactors over public highways on which petitioners' members travel cannot take place without construction of the facility, it can't be fairly argued that the threatened injury to the petitioner's members is not caused by the challenged licensing action. Indeed, the unique circumstances surrounding the transportation of MOX fuel over unannounced routes with unannounced schedules in unmarked trucks precludes the petitioner's members from being able to avoid the asserted harm to their health from the shipment of plutonium over the highways. Additionally, and most obviously, the asserted injury to the health of petitioner's members would be redressed by a decision favorable to the petitioners denying the construction authorization for the MFF. Finally, the interests that the petitioners seek to protect by challenging the construction authorization are germane to the purposes of the environmental organizations. We believe that constitutes, in a very concise fashion, our arguments here, and that the board should grant all of the joint petitioners. Stan, thank you.
Any questions?
No.
No questions. Thank you, Mr. Lodge. Mr. Ott, before you begin, I mentioned yesterday, I think when we get to the next phase and we have questions from the board, I will have some questions about the specifics of the declarations that you submitted on behalf of your clients. So if you could try to focus your comments, since we will be dealing with the specifics of the declarations later. So if you would try to focus your comments primarily on the more generic issue that's been raised by Mr. Lightly, I appreciate that.
Yes,
Thank you.
good. With that assurance that we'll be able to speak
Absolutely.
in response to some of the criticisms of the declarations, I'll try to focus on the broader issue regarding stating. I want to disabuse the panel of the idea that there is no proximity-based standing for isthmuses. There are at least 3 cases in which that's proximity-based standing has been found for such facilities. There's the private fuel storage case, of course, 1998. That's 47 NRC 142. There's the Pacific Gas and Electric case, a 2002 case, and that is cited at 56 NRC 413. And of course, there's the Holtec case from earlier this year, and that's LBP 1904. So certainly those cases are examples where proximity-based standing for istices has been validated. Now, there are other non-reactor cases in which proximity-based standing has been found, that those are less specific to our claims here, and so I think it's important to recognize that there is precedent for istices having a basis for proximity standing. Second, there's the argument that somehow the emergency planning rule negates proximity-based standing. Well, that is also, I think, refuted by the precedent that I just mentioned, and the fact that the emergency planning rule was adopted in 1995. Subsequent to 1995, in private fuel storage, Pacific Gas Electric, and Holtec, we have instances where, in the context of those cases, the emergency planning rule did not preclude proximity-based standing. And I think that that precedent stands as a basis for this board to find that under the facts that have been advanced, that there is a basis of proximity-based standing, and it's not undercut by this emergency-based or emergency planning rule. And with that, I would ask the panel to allow me to also adopt by reference and incorporation the arguments that have been made by Ms. Curran previously this morning.
Of course. Any questions at all?
Are we going to get into specifics now?
I think later, yeah, specific
No.
declarations. Okay, thank you. The NRC staff. Mr. Gillespie, and I have a comment or question before you begin.
Okay.
Just to recap, in the staff's initial filings, you did not oppose the standing of Beyond Nuclear, you did not oppose the standing of Sierra Club, and you did not oppose the standing of Baskin, the two entities, one individual and one entity, we collectively call Baskin. Initially, you opposed the standing of the joint petitioners, but as of yesterday, I assume today, you do not oppose the standing of Seed, one of the joint petitioners. So from that, I take it that you disagree with Mr. Likely's analysis of what is necessary to show an obvious potential. So that's the itch that you might try to scratch, if you would address that question specifically.
Yes, Your Honor. Frankly, we disagree with the applicant's position interpreting our EP requirements to apply to standing. The AEA sets forth that the commission must give standing to. It doesn't give a floor as to who may be granted standing. Additionally, the case that they mentioned, the Ross ISR case at CLI 1212, mentioned by the applicant, is not fully dispositive of this issue. While the commission said that the 50 miles proximity presumption roughly corresponds to EPZ ingestion pathways, they said the commission stated that it's a application-specific determination as to what might be a particular radius for individual application.
I'm sorry, I can't understand.
Yeah, if you move the mic, that mic is
Yes,
very sensitive
it
in
is.
direction. Yeah, I think that's better.
Would you like me to repeat, or did you?
I think, well, it'll be on the written record, but
Okay.
I'll just continue at this point. Thank you.
Additionally, we wanted to answer your question about discretionary intervention. There were 9 cases we've identified where discretionary intervention was granted that were not overturned by the commission. These are not a particular order: Pebble Springs and A-Lab 362, CLI 93-3, LVP 9138, CLI 8215, A-Lab 670, A-Lab 363, A-Lab 397, LVP 79-1, and then LVP 09-6, which in the I was granted discretionary intervention in the Yucca Mountain proceeding. But let's also kind of have standing as a matter of right.
You know, shows I'm getting too old. We did that, yes, that's right. But there hasn't been one probably since then, right? That
No, there aren't.
10 years ago.
There is not.
I think.
And that's all, unless there were any specific questions you had for us.
No.
Any questions? No. Yeah, we'll take a short, thank you, Mr. Gillespie. We'll take a short, very short break if we can, and convene promptly at 10 o'clock. Thank you. All right, we are now into our third and final phase of this proceeding, which is the opportunity for the board and for individual members of the board to ask questions about aspects of the particular petitions that concern us. Generally, as we do this, if a board member wants an answer from a particular individual, we will say so. And if we want an answer from two people, we'll direct the question to two people. If you do not have a question directed to you, and you have an overriding desire to comment immediately, raise your hand and we'll probably recognize you. We're fairly informal here, but generally better to wait your turn and follow up further if you can. I think the way we intend to proceed, and the logistics here are a little difficult, but I think we're going to go through petition by petition. Ms. Curran, you are in luck. We have no questions to be obvious. So I think physically the easiest way to do this would be to have us in a position to ask questions simultaneously of the petitioner who's at bat, the NRC staff, and the applicant. I hate to put a burden to stand on the petitioner, but I think it will work best because the applicant will always be up here. So you get to take a table for the time being, if you would like. The NRC staff can take the table.
No.
No?
Podium.
The staff can't be at the podium. The staff is at the podium all the time?
Yeah. Sure. You said your questions were going to stand.
I had two questions, in any event. We need to confer. Okay, we have conferred. We know the petitioners are in excellent shape and do not mind standing briefly. So we're going to allow the NRC staff to take a table. The applicant has a table, and the applicant and the staff will stay in those places, and we will have the petitioners come up, the three remaining petitioners, one at a time, and we will ask our questions. So if Mr. Taylor, I could ask you to come up to the podium. And I apologize for making you stand, but we don't have enough tables, I'm
If I
afraid.
can use this part of the table here.
You are welcome to use part of the NRC's table.
Oh, let's keep the corner.
And let me start then. I think my first and probably only question, yes, my only question actually is for the staff. And this is the question on Sierra Club's contention number 1. That's a multi-part contention, I believe. But one aspect of it challenges having the option in the application to either have DOE as a customer or to have a private energy company, a power company as a customer. Now, when Beyond Nuclear made that assertion, the staff still says that's an admissible contention. Why does the staff not find Sierra Club's contention 1 admissible, at least as to that issue? Who would like to address that?
Your Honor, I will, can I just a minute?
Yes, yes.
contention to be focused on the idea that the inclusion of nuclear plant owners was a fig leaf, and that what they were trying to litigate was that that was not a likely outcome, that anyone other than DOE would be willing to take title to this waste. And we view that argument as concluded in part by the Holtec ruling that the NRC is not in the business of regulating the market strategies of licensees.
I'm sorry, we
Or-
can't hear you.
Or
We
determining
can't
whether-
hear you.
Can you speak a little more direct, speak a little more slowly, might help, directly into the microphone?
Yeah,
Thank you.
actively, that they were focused on the idea that the Sierra Club noted that the application had changed, that they were now including nuclear plant owners, but that was a fig leaf, that they, and that is not admissible because an application is allowed to change. And because the commission does not regulate the market strategies of licensees. So the staff did not see in their contention a concern about including DOE as an option. Rather, we saw a contention that was trying to litigate the idea that the inclusion of nuclear plant owners was out of reach. So that's why we didn't see it as admissible.
Okay, I understand the staff's argument, and you're welcome to make a comment, Mr. Taylor, but I think I understand what the staff is doing. Anyway, let's leave it at that. Yeah. And if you could move your microphone a tad to a little more directly in front of you, that's a very sensitive one. It works at a certain angle and not at others.
Let's try that.
It's fine for us, I'm concerned about people in the back.
Move the, that worked.
Yeah, how's that? That's too much.
Too much, I don't know what's happening now. Let's let that calm down.
How's that?
It's obviously not good.
I'm shutting it off and turning it on. Is that better?
It's certainly better than that. We'll try to articulate it as best we can, but let's continue.
I guess I didn't see that particular distinction between our contention one and Beyond Nuclear's contention. We certainly are continuing to assert that having DOE take title is illegal and cannot be licensed, and that the nuclear plant owner, an alternative, was an afterthought, and we believe that the panel should consider that in determining whether or not that's an appropriate alternative. And I thought Beyond Nuclear made that a similar argument, so I'm not quite sure what the distinction is.
I think I understand that this was an intentional act by the staff. I may agree with you, I think they're similar. But in any event, I think that answers the question. Okay, all right, let's proceed. Those are the only questions I have with respect to Sierra Club. Dr. Kouros?
Well, yes, I have questions regarding, to begin with, contention 4. I have questions to begin with regarding contention 4. In your petition, you refer to table 429 of the environmental report, and you contrast the doses associated that are presented in that table with, this is for loss of shielding accident, transportation accident. And you state that the doses are far smaller than those that appear in table 1 of your petition. I just wanted to affirm that it's the difference between that analysis that you refer to in your contention for and the ER analysis for the basically same thing that is the basis for your contention.
Yes.
And I would like to hear from the applicant as to why that they feel that that doesn't constitute an admissible.
Thank you, Your Honor. Ryan Lighty for ISP. The presentation of an alternative conclusion does not show a defect in the application. There's no explanation as to why the application's analysis is somehow deficient. In other words, it's simply saying, I have a different study. That study is admittedly a worst case analysis, which is not required by NRC, does not show a genuine dispute on a material issue of law or fact with the application. So simply saying, here's a table that has some numbers in it, and there's a table in the application that has different numbers in it, doesn't explain a defect in the application, the analysis, or the methodology.
So what you're saying is that the Sierra Club would have had to go into all the details of the input and assumptions and calculation method of the environmental report, find defects in that, and then present those as contentions.
What I'm suggesting is that the petition says you're wrong. It does not say you're wrong because. The absence of the because explanation is what renders the contention inadmissible.
Which is what I think is what I just said, that you have an analysis. The analysis has inputs, the analysis has assumptions, and an analysis has a calculational method. If the analysis is wrong, it has to be wrong in one or more of those three areas. Therefore, one would have to have those three areas, the information from those three areas available to be in a position to argue that they're wrong. That really isn't the case in the environmental report. And I don't get it wrong, some of the information is available in the environmental report. But it seems to me that an alternative is to present an analysis that says, we did an analysis the same way you did, or the same methodology we did, and got a significantly different answer. Now, I can understand if the answer is 5%, 10%, 20% different. But in this particular case, the analysis that's represented is significantly different than multiples.
Yeah, I agree. That's not surprising given that it is a worst case analysis that's not required by NEPA. But to the extent we're talking about the methodology that's described in the ER, they still don't challenge what pieces of the descriptions of the methodology that they disagree with. They simply present an alternative analysis without explanation. And so it's not necessary to have all of the proprietary computer files. That's not what we're saying. That's not necessary. But you must challenge what is in the application, and the description of the methodology is in the application. And there's no requirement to go further to do a worst case analysis which is what they're attempting to present as having different conclusions.
So what's the basis for, what's your basis for saying that unless you know, can be very specific with respect to the ER analysis, that unless you can do that, having an alternative analysis is not acceptable? I'm not, that piece I'm not getting. I mean, the end result of all of this, as I see it, is that a member of the public has to know what kind of dose they're getting from a non-incident and an accident transportation of, let's say, a number of cats that carry radioactive material. That's the bottom line. Is the public confident that we know the answer to that?
Well, to the extent we're talking about data that's in the proprietary files that petitioners didn't request access to, that was their choice not to request access. Judge Tricros, as you may recall from the Seabrook proceeding, a board that you were on, there was a contention regarding the unavailability of Sunsi information, and the board there rejected that as a contention because it is incumbent upon petitioners to request access to proprietary information if they feel it's necessary for a contention. To the extent they wish to dispute that information, they had the opportunity to do so in this proceeding and elected not to do so.
Well, you know, we've dealt various times with contentions that involve doing the same calculation with different methodologies. So, you know, one and the other have different inputs, et cetera. And the contention was based on the fact that one methodology, a credible methodology, gave a different answer than the one in question, without going into the details of the calculation in question. So it's not clear to me that it's unless you can explain to me why it's an absolute requirement that an alternate calculation method cannot be utilized as the basis for a contention. I'm confused.
I would refer you to our answer pleading in 2 Sierra Club on pages 46 and 47. We included an extensive block quote from the Commission's decision in CLI 12-5, and I'll read just a brief excerpt from that. A contention proposing alternative inputs or methodologies must present some factual or expert basis for why the proposed changes in the analysis are warranted. For example, why the inputs or the methodology used is unreasonable, and the proposed changes to the methodology would be more appropriate. Otherwise, there is no genuine material dispute with the analysis that was done. Only a proposal for an alternative Nuke analysis that may be no more accurate or meaningful.
In this particular case, the analysis methodology that we're talking about is, I believe, identical. We're talking about RADTRAN, so they're using the same methodology and coming up with different answers. What you had read doesn't directly apply to this situation.
I see.
Okay, that's fine. So I understand your position on this.
If I may, just one brief additional point. So the methodology and the inputs are described in Chapter 4 and Attachment 4-1 of the ER. And in a nutshell, the inputs to the RADTRAN analysis are directly from the regulations in Part 71. So those are not hidden from public view. Those inputs are the NRC's standard inputs versus the Lamb-Resnikoff analysis, which used different inputs, worst case scenario inputs, which are not required.
Yeah, I understand. And indeed, that it is specifically identified as a worst case analysis in the title. Okay, go ahead.
May I respond?
Sure, of course.
First of all, regarding the title of worst case, I think that when,
Yeah, see if you can put that closer to you.
with regard to the worst case argument, I think underneath a worst case means the impacts, the overall impacts that are being addressed. Here, as you indicated, Judge McCurry, what we're looking for is what can the public expect as a dose that they'd be exposed to. And certainly they would want to know what the worst case would be. And I think that's what this is referring to in the study, rather than the NEPA that definition of worst case. But beyond that, I think what the applicant is suggesting here is an analysis or an exposition in the contention that goes beyond what's required for a contention. You don't have to present an entire case in your contention, and we certainly have in this contention set forth Dr. Risnikoff's analysis. We referred to his report, gave a citation to it, and explained why he disagrees with the result from the ISP's analysis. I think that's all that's required.
Yeah. I mean, this is a fairly complicated situation because it's very clear to me that unless you do specify particular inputs or particular problems with the analysis, it would be incredibly difficult to litigate an entire analysis that involved hundreds or perhaps thousands of inputs and assumptions. So clearly, in order to be able to litigate something, you would have to have something specific to have a hearing on, let's say. But again, we do have the question that the result is significantly different than another analysis. So, I guess we have to deal with that. Does the staff have any comments on this at all? You initially admitted the contention. We went through this yesterday.
Your Honor, the staff does not have any further information on this specific question.
Sorry.
Oh, I apologize. The staff does not have further information on this unless there's a specific question.
And your position is it's not admissible at this time?
Yes, Your Honor.
And I will also point out that the staff, in doing their analysis of their review of this, felt obliged just recently to ask for input information, assumption information, input decks. So clearly, if they needed to ask for all that, and I mentioned this yesterday, they needed to ask for all of that. It wasn't available in the environmental report, and clearly it wasn't because they did ask and received all of that. So I think that's the difficult question that we have to deal with.
If I may, Your Honor, just very briefly, I would note that if the petitioners had the same concerns that the staff raised in their RAI, they had the opportunity to raise those concerns in their petition, but did not. And so the fact that the staff could envision some omission from the ER doesn't mean that the petitioners alleged that in their petition. We're here to talk about satisfaction of the 2.309 feeding requirements. And so I don't think it's appropriate to incorporate the staff's questions in an RAI to the petitioner's petition. And one final point as to the inputs. I agree there may be hundreds of inputs into a calculation. Our position is not that petitioners would need to challenge every single one, but just a challenge to a single input. One explanation of why it was inappropriate to use the NRC regulation in Part 71 as the basis for the inputs into the RADTRAN calculations. There's no explanation of why the inputs that Land Resnikoff used are somehow better than the Part 71 inputs. There's just no explanation for why there's a difference in the inputs right into the review.
Yeah, and I think one other complicating factor is that in the letter that was sent to the board notifying us of the reanalysis that was done, that reanalysis did point to other studies, other credible studies of the same thing that resulted in answers that were very similar to what you were getting in your analysis. So the question then becomes, is the resident cost study an outlier, or does it represent a more conservative analysis that should be seriously considered? But I don't think we have any other, and I would love to have other people comment on this. I think we're done.
If I may, Your Honor, one other brief point. While we're talking about transportation analysis, I know Mr. Lodge earlier made a number of references to there being something on the order of 30,000 shipments to the facility. We would just like to correct the record that is orders of magnitude different than what the application proposes, which is something on the order of 500 casks total. So assuming that there were only a single cask per shipment, that would be orders of magnitude different. I'm not sure where Mr. Lodge is coming with 30,000 transportation shipments. Is it correct?
In the analysis of the shielding, of the loss of shielding accident, the reanalysis references 40,000 an exposure, a burn-up of more than 40,000 megawatt days per metric ton. Was that, do you know if that was a change from the way it was originally done? And the other question is, why 40,000? The boundary for high burn-up fuel is, as I understand it, and somewhat subjective, arbitrary, is 45,000 megawatt days per metric ton. But on the other hand, I believe the fuel in your facility is at 45,000 megawatt days is canned. Would that be an argument for utilizing, not utilizing 45, but utilizing 40, since the 40 would not be canned?
If I may have a moment, Your Honor. Thank you, Your Honor. So there was no change in the analysis on that basis. The value comes from the design basis for the MP197 cask. That is considered a conservative analysis, and so that's why that value was used.
All right, and the reason I asked the question is there was a confusing change. The reanalysis included changes to the ER. And there was a change to the ER that took out the statement that the dose that was assumed for the casks in transport was the maximum dose that would be allowable to transport as per Part 71. That was removed, and it appears that the 40,000 megawatt days per metric ton was put in there. Now, my understanding of this is that for non-incident transportation doses, the maximum Part 71 dose from the cask is assumed at a meter or 2 meters, I forgot what it is. And that for the loss of shielding accident, which would result in a release of radioactivity from the gap of fuel cladding gap, would exposure or burnup would be appropriate to use there. You know, a conservative exposure. Does that make sense?
I
Am I getting too much into the weeds of this thing?
A little bit, Your Honor. The design basis of the MP 187 is what was used, and that is a conservative analysis. Maybe I'll turn it over to Mr. Matthews.
Thank you, Judge Cross. I'm jumping in because this was not part of the detention response, but I did review the RAI response. The source term was used only for release. Part 71 limits were used for exposure, and I note that the transportation cask exposure limit is governed regardless of whether it's 40 or above 45. Whether it's high burnup or not, you're still limited by the transportation.
Right, and that, I assume that's for the non-accident analysis, the what they call non-incident transportation evaluation. No?
So we did not use those source terms, for instance. We did not.
Okay, because as I said, originally in the ER it said that the maximum Part 71 assumption was made. Those were passed down at 40,000 megawatt days per metric ton was added in the update.
At the risk of having to correct another misstatement, Judge Charles, we will
That's
be
fine.
happy to get back to the board, but note that this is an interesting aspect of the RAI that some far afield from the rest of it.
That's fine, it's not critical that I can.
Your Honor, if I could maybe perhaps give some input. The dose rate in Part 7147 for external radiation standards for all packages, 7147B3 is 10 milligrams per hour as a 2-meter delay from the outer lateral surface of the vehicle. And the RAI response in page 26 of their updated ER page references a 14 milligram per hour dose rate at 1 meter. So he claims based on an estimate from the 10 milligram per hour at 2 meters from the external surface. Sorry, not external surface.
10 milligram
away
per
from
hour
the
at what?
vehicle.
Okay, but now, with respect to the staff, they're in the process of doing an independent evaluation of this. And I say that because they just asked for the input at the end of June, so we're not that far away from that. And yesterday you had said that you don't anticipate any change to your position on admissibility, but
That is
but
correct.
you don't know what the outcome is of the independent evaluation at this point, right?
That is correct. The staff is still undergoing its review. However, the RAI response and the regulations specify the external dose rates. I believe that was your question.
Judge Arnold.
Yes. On page 31 of your petition, you cite 10 CFR 72.108 as requiring a nuclear waste storage facility be evaluated with respect to the potential impact on the environment of the transportation of the radioactive waste. But if you look at that 106, it consists of one sentence, and you left out the final part of the sentence that requires this evaluation to be within the region. Considering that this application is for a materials license and doesn't authorize any shipping or any shipping routes, what do you see as the appropriate interpretation of within the region?
Sounds like a trick question. The Sierra Club's position is that our interest is for the persons within what the ISP itself calls region of interest. Certainly, it seems to me also that although I don't represent Mr. Lodge's clients, I think they certainly have an interest because the storage facility would not even exist if not for the transportation of all the waste from different parts of the country. So I think wherever that waste is being transported and stored, anywhere that a person would be exposed to safety concerns, or there may be environmental impacts, I think that would be the region that would be necessary to evaluate for the ER.
Given that they've done this evaluation for specific transportation routes, do you have some reason to believe that the environmental impacts would be different on different transportation routes? Other than correcting for population.
I could foresee that if there are certain areas where perhaps the rail infrastructure is not as good as it might be other places, that would be a concern. If there are routes where there may be more trips than other routes. For example, there are many reactors in the northeast and the southeast area, so there may be much more transportation risk from the east coming west toward this site than there would be from the 2 or 3 reactors in California, for example.
On page 43 of your petition, you assert that the specific details of the CAS system are important in evaluating the impacts of transporting radioactive waste. But I don't see anything in the discussion that supports that assertion. What do you have to support your assertion that the different type of CAS, being that they're all certified, why does the type of CAS make a difference?
Well, I think that the statements, rather declarations of Dr. Reddercoff and also Dr. Gordon Thompson indicate that they are looking at the specific tasks involved, and certainly the documentation that we referred to, the NUREBs, I think are based on particular tasks, and it just seems, I guess, sort of common sense that different tasks might have different factors that would go into whether a certain acts need to be done in order to make them safe. Each task is evaluated by the NRC individually. There's no generic task certification. So I think the NRC itself acknowledges that different tasks have different aspects that need to be evaluated.
Okay, but the rest of my questions are for the applicant. In your answer to the petition, you in fact pointed out that that petitioners had given no justification for their assertion. Do you have any support for the implication that the type of CAS evaluated for the Transportation analysis, in fact, really is not significant in that analysis?
Off the top of my head, I'm not familiar with that as a technical matter, but as a legal argument, I would note that the burden is on the petitioner to demonstrate the materiality of their contention. And they have not done so. They haven't even attempted to do so, and I think that's dispositive.
Also, the Sierra Club faults your analysis for not considering the increased traffic of oil tanker cars and the fact that these can cause higher fire temperatures. Why do you not consider oil fires important?
For the reason that we intend to ship by dedicated train. And as the board noted in LVP 19.4, there will be no flammable oil cars with the shipments that would come to the facility.
I just needed to hear that for this one. Okay, Sierra Club asserts that the railroad infrastructure is deteriorating. Could such deterioration be cause to question the applicability of the earlier transportation studies?
No, the infrastructure would be evaluated separately in the Part 71 transportation route selection and approval process. It's not part of this application. It will be considered, and the FRA has to approve those routes. So we have to assume that they're not going to allow shipment over routes that are unsafe.
And would this maybe provide some support for your assertion that analyzing a specific route can be representative of other routes because whatever route is chosen is going to be verified to be of decent quality?
Correct. That's an approach that the NRC has used for many decades to analyze representative routes. And as noted in LVP 19-4, that's a sufficient basis for a NEPA.
And do you have any responses to those?
This is our one chance to challenge the licensing of this project. And to have the applicant say, well, the safety of the rail will be decided later, then we don't have any chance to have this kind of input and ability to challenge the licensing at that point. So I think this is our one chance to do that, and we've done the best we can with the information we have available right now. And I think that it's not the NRC's policy to do this kind of piecemeal approach, that this is our one chance to challenge the licensing in National Rail.
Thank you. That's all the questions I have on that contention.
Dr. Carl, do you have more questions?
I just had one more on contention. Sierra Club contention 13. In your petition, I think it's on page 79, you state that the ER 3.4.16 cites several sources, but the sources are not described well enough to allow members of the public to access the sources. So, well, first of all, I think you meant 3.516, right?
Yes,
Okay.
that's right.
So I'm sure. And
My computer made a typo.
and can you explain that a little bit further, please?
Sure. If you look at that section, at the end, they cite their alleged references that they were using, but there's no URL to go to, there's no citation of a journal that you can go to, and I Googled on all of those, and I couldn't find anything. And the NEPA regs, and I certainly say that the applicant has to at least show that they've provided a thorough analysis and the sources so that the public can comment and be advised of what the ER relies on, and that wasn't done.
And now the applicant, from the point of view of the applicant, you included them, I think there were 5 of them, and they were rather cryptic. Is there any reason, but however, they were quoted in the ER very prominently. But what was quoted were the results, ostensibly the results of these studies. Is there any reason why you didn't include them as formal references or provide some, even the titles of the reports are not there. So it would be rather hard to Google something like that. Is there any reason for this?
Your Honor, I can't speak to why the precise language was used in the original ER describing the reports. The fact of the matter is, there is no requirement that a reference, contrary to what Mr. Taylor said, that a reference be publicly available. And in response to the questions, we did look to whether they're publicly available, and at the time of the petition, they were not. But the real issue focuses on what's in the ER itself. And the ER describes the conclusions of those reports in extensive detail. So what Mr. Taylor had the opportunity to do as any petitioner is to look at that detailed information and challenge that information as cited in the ER. And I would remind the board to look at the very contentions, CR Club 13. It really contains 2 sentences on all of that information. There does not appear to have been an adequate survey conducted to determine if the species are resident in the area. That's it. And then it says, the sources are not described well enough to allow members of the public to access the sources, so the public and the NRC are left with only unsupported statements in the ER. That's the entirety of their contention. They had every opportunity to go through the multiple sections, multiple chapters in ER section 3, 4, and 5, and challenge any of that information, provide studies, expert report. So the issue is what's in the ER, not what's in those cited sources, and they've done nothing.
Well, they are challenging the conclusions by saying that there are no adequate surveys because you didn't provide any surveys.
Yeah.
And it's almost like you and I having a conversation, and I say, well, I read this somewhere, give you some facts. It doesn't help, there's not much you can do regarding that. You might just shake your head and not believe it, but you have no basis for anything else.
Well, Your Honor, as Mr. Ryan said, as we've noted, there's no basis to assert what we've said in ER is inadequate or incomplete or somehow inaccurate. It provided no information on that. And it's their burden at this point to say what is in the ER is somehow inaccurate. In addition, as I noted yesterday, we do reference a 2015 response from the U.S. Fish and Wildlife Service that is included as an attachment ER 3.3 to the ER that discusses endangered or threatened species. And that was not reviewed or even referenced. Further, just as a reminder, neither of the sand dune lizard or the dune sagebrush lizard is not even a threatened or endangered species in this proceeding.
May I respond?
Yeah, of course.
Sure. Well, first of all, the discussion, if you want to call it that, in the ER regarding these 2 species was pretty limited and not very lengthy. And with respect to the Fish and Wildlife Service, these 2 species that we're concerned about here are state species, either threatened or concerned. And the Fish and Wildlife Service is going to be just dealing with federally listed species. So that's kind of a red herring, which is not an endangered species apparently. And I still say that if they're going to rely on these sources, they have to give us some way to go and find them and review them and comment on whether those sources were adequate to reach the conclusions that they made in the ER.
Was the staff able to find these cryptic studies?
Your Honor, Thomas Sedgwick, head of the staff. Judge,
we can't understand?
No, the staff is not able to find these studies. However, our response to this contention is that it is admissible because the Sierra Club does not explain how this creates a material dispute with the application. It doesn't, their contention does not meet the 2.09 F1-6 criteria for admissible contention.
Let me ask you a question. Here's one of the 3.5.16 descriptions. The first one. The ecology group conducted an ecological assessment in 1997. Can you tell me from that description how many people performed the survey, what their qualifications were, and how much time they spent on the site?
No, Your Honor.
Wouldn't you need to know that in order to determine that the information from that survey is credible?
Your Honor, may I have a moment to consult?
Pardon me?
May I have a moment to consult, Your Honor? To consult the staff.
I did not understand that.
I'm sorry. Your Honor, may I have a moment to consult the staff?
Yes.
Thank you. Thank you, Your Honor. The staff has requested more information on this NRI, and based on that, based on that response, we determined that more information is necessary.
The information provided in the environmental report provides a staff baseline information from which they can start and do their environmental study, right?
Correct.
Is it not useful to the staff to know that the information provided is credible so that they really have a base point to start their study from?
Yes.
Okay, let me ask the applicant, do you think that the information you provided on the surveys is adequate for the staff to say, oh yes, those survey results are credible?
Your Honor, I believe the information in the environmental report fully complies with Part 51, NEPA, and the NMSS guidance on environmental reports efficiency. And contrary to what Mr. Taylor said, that the scant information, I would refer the board to section 3.5, 3.5.33, 3.5.4, 3.5.56, 4.5.8, and ad nauseum, we talk about the habitat, the environment, the area of a 5-kilometer area around the CISF. We talk about species found in the CISF. That is all that's required of the applicant. I understand that Mr. Taylor would like or prefer to go find the source information, but he has cited no information, no regulation, no case law that requires the applicant to do so.
Yeah, but that information has to have a basis, right? I can't just say, this is the habitat of this animal, and it's not present here, without some basis for that, some study, some reference somewhere that supports that statement. This can't be a battle of opinions. This has to be a scientific, technical process, correct?
I understand what you may be discussing is perhaps what NRC may want for its review. But what here we are talking about has Sierra Club provided a basis for contention. And in my opinion, that they have the burden to somehow prove, I mean, there's a presumption of what we provided on a signed application by a company representative is complete and accurate. They provided nothing to assert that that is not complete and accurate. There should not be a presumption that we are wrong in this information unless they could have provided a study somehow saying what we provided is wrong. They provided 2 sentences, that's it.
Well, you quote 5 studies. And this was a technical analysis, correct? This is a reputable organization that was hired to do this. And they say, I got this information from these 5 studies. I don't understand why it's such a big deal, so to speak, to provide a reference to the studies that one can access. You know, in the legal world, you know, they're citing, 100 sites per, page to things. They don't say anything without a site. The same standard really should apply to this. I would think. I just don't understand why to me, it's valid to say that the statement is not supported. If it's a simple statement with reference to a study that hasn't been properly identified.
Well, I mean, from the ER, we know that those studies were part of the rate control system, low-level rag rate license application. So we know that's evident from the ER. I don't have the citation right now. So it was part of another proceeding. It has legitimacy. And I understand, Your Honor, I understand your point. But we presume the information in a signed application by an applicant is somehow incomplete or inadequate without more. I think it's an invalid assumption. It's not their burden to prove that.
Let me see if I understand the availability or non-availability of these studies. Obviously, if you had decided, as a matter of your discretion, to attach them all to the application, they would have been available. Short of attaching the studies, are they publicly available? I mean, is there any reference you could be giving that would allow Mr. Taylor to go find those studies, or are they not?
Your Honor, I would have to confirm, these were studies prepared by Waste Control Solutions as part of the low-level rag waste facility. I suspect we could find, excuse me. Your Honor, as I said, they were part of the low-level rag waste facility application, and they are referenced in that application, and that application could be available.
But you say the studies were referenced in that application, but would they have been attached to that application, or?
As I was not involved with that application.
Okay, your colleague is nodding. If you want to make that a representation of counsel,
so the answer is
they would be
yes.
all right. So,
But we did not, to be honest, I mean, to be clear on it, we did not, in our answers say they were publicly available, because we're part of an application that was not readily accessible online.
right.
But again, I want to emphasize, there is not a presumption that the information we presented is somehow incomplete or inaccurate. And they have not provided, not a scintilla of evidence that that's true.
If I can respond, I don't believe, as I recall, that there was any reference in this ER to the local right waste document that the council refers to. So how am I supposed to know that to go to that document to find these sources? I'd also point out, just in terms of our pointing out the portions of the ER that we are taking issue with. On page 78 of our petition, we note that the horned lizard and sagebrush lizard are in the area of the ISP site, and that comes directly from the ER. But then, with no factual support, in section 4.5.10 of the ER, they claim that the project will have no impact on the species. That just seems like a contradiction that is not explained, and the reason I said the adequate survey was conducted is because they haven't set forth any facts or information as to what kind of survey, if any, was done.
Your Honor, if I may address that, I think they're misinterpreting the application. In section 3, chapter 3, we talk about the survey results in the CISF area, which is a 5-kilometer radius around it. And it talks about the general habitat and the sightings of those species, very detailed information around that area. Chapter 4 talks about the impact of the actual CISF facility, which is a much smaller size. So there's no discrepancy there. Yeah, I believe that they're just misreading the application.
Yet, in reading that section of the ER, it struck me that the conclusions that were reached were sort of left hanging with respect to sources as indicated in the contention. For example, if you say that the study found that these were not, the dunes sagebrush lizard was not present within 1 mile of the site in the study. It just says the study. It doesn't say, the study of this title on this chapter or this page of the study. There's no more than just a bare conclusion. Bare conclusions are no less unlike in the technical world as they are in the legal world.
I'm not sure that was a question.
Yeah, I understand. No, my question was, why didn't you refer more to the study in depth when you reached a conclusion in the ER? You reached many conclusions, but you didn't, even if I had the study in front of me, your conclusion in the ER wouldn't have told me where to go in the study to find it.
Your Honor, I understand your point, but we believe we fully complied with NRC's guidance in Part 51 NEPA and the applicable new regs regarding describing the environmental baseline. We did describe the environmental baseline, and we believe we complied fully with NRC's requirements on
The door, we have more questions?
Not on this contention.
More questions on other contentions?
Sure. Going back to contention 8, having to do with ISP mischaracterizing the Blue Ribbon Commission's report. The first sentence of your basis is, quote, ISP takes the position in its ER Rev 2, 1.1 and 2.1, that the purpose and need for the CIS project is dictated to a great extent by the BRC report. Well, I read over those sections and I really didn't find anything that sounded like that. So could you be more specific? What were the words that they said?
I don't have that right in front of me, Your Honor, but they said various places. In fact, even in other portions of their documentation, that this CIS would carry out or comply with the recommendations of the Blue Ribbon Commission. I think that's pretty explicit in all of the, in a number of areas of the documentation.
Well, let me just ask, The applicant, to what extent does your application rely on the Blue Ribbon Commission and its report?
Your Honor, we do reference the Blue Ribbon Commission, but it's nowhere that it states, our application states, that it even implies that the project is dictated by the Blue Ribbon Commission. There are 7 purposes of the proposed project, and you simply referencing it at the CISF is consistent with one of the goals.
On Sierra Club Contention 10, about the aquifer. On page 66 of your petition regarding high burnup fuel, you state, quote, "The damage to the cladding likely leads to leakage of radioactive material from the storage container." Now that doesn't seem clear to me, I mean, especially since it's also canned. So do you have any support that the leakage is likely?
I've referenced 2 publications on page 67 that I believe supported those allegations. And we also have, I think it's 16 concerning high burnup fuel. And that DER in discussing the groundwater did not address any of that risk from high burnup fuel.
I didn't see anything that addressed how the leakage would get through the canning. Just basically, it seemed to be a jump from fuel leaks, so it's going to get out. Okay. Having to do with Sierra Club Contention 11, this was about the site selection criteria. Can you direct me to any legal requirement that the site be selected based upon environmental considerations?
Well, what you have to understand is that this whole discussion of site selection is under the section of the ER regarding alternatives. And so certainly, the ER has to discuss the various alternatives, how they were chosen, whether they're reasonable alternatives, and then to discuss the impacts regarding each alternative. So that's the point here. The NRC staff thought we were talking about purpose and need, but we're not. We're talking about the selection of alternatives.
On page 71 of your petition, you state, quote, "The ER contends that no contamination of any kind has been detected from the adjacent LLRW site, low-level radway site, near the proposed CISF site. There is nothing in the ER, however, to substantiate this allegation." When I read over that section in the ER, I saw that the previous sentence, right before what you cited, was, quote, "The waste control specialist site has been under a monitoring plan to detect the release of trace amounts of radiological and hazardous chemical constituents since it was permitted and licensed in 1997. It seems to me when they say it's been under constant monitoring and no leak has been detected, that in fact substantiates the claim that there's been no detected. And I don't understand why you say there's nothing in the ER to substantiate the allegation. Do you want to a list of dates and below detectable activity, is that what you're looking for?
Well, it didn't appear to me that there was enough information there to support their statement. But the bottom line with that particular point A on page 71 is that contamination or the leakage from the low-level site is irrelevant to what we're talking about here. We're talking about leakage or pollution or the contamination from the proposed site up to the groundwater.
Okay. Let me ask applicant, on page 72 of the petition, the Sierra Club notes that you state the facility is not within the 500-year flood plan. And then the Sierra Club goes on to assert that you need to address the impacts associated with the 100-year flood plan. The question to me is, isn't the 100-year flood plain completely encompassed by the 500-year flood plan, so that your statement that the facilities is not in the 500-year flood plain explicitly said, or implicitly says it's not within the 100-year?
I believe it would be bounding, but I would also point you to ER page 3-20, which says that it's not within the 100-year floodplain.
Okay.
It explicitly addresses the 100-year.
Great. I'm done with Sierra.
Thank you, Judge Arnold. Mr. Curtis? Thank you, Mr. Taylor. Thanks for standing that period of time. Well, let's take another break and resume at 11:30. Well, so people are seated. Despite contrary indications a few minutes ago, we're still optimistic that we might be able to finish this before lunch. I'm guessing we might go on past 12:30 a little bit. I think most people would prefer to do that and break after lunch rather than break before lunch rather than have lunch and come back. I think part of that assumes, we talked a little bit about it yesterday, whether the parties after a day and a half really feel it would be productive to have 5 minutes to say something. And I'm guessing that if we can finish before lunch, there might be a sense that that's not really necessary. You can think about that and make an argument if somebody feels that we need to do that. But otherwise, we have 2 more petitions to handle. I think we're going to try to be as crisp and efficient as we expect you to be. And I see a question from the Office of General Counsel.
Yes, Judge Riveson, Thomas Seco from NRC staff. I'd like to correct something I said earlier regarding the RAI related to Judge Arnold's question on Sierra Club Convention 13.
Yes.
So the RAI that has been issued is to seeking studies that are the most recent studies as required for the licensing condition of the WCS site for the state that Texas requires. It's not to request the studies listed in 3.5.16.
Okay, thank you. All right, Mr. Lodge. I have no further questions for you. And we'll start perhaps this time with Judge Arnold.
On contention one, actually, this is a contention one question for the applicant. On page 42 of their petition, joint petitioners claim, quote, ISP has thus segmented the indispensable transportation component of the project proposal from the storage component. Now, did you choose to do this segmentation, or is this basically how the rules of the NRC require you to do it?
Your Honor, the transportation analysis is analyzed as a connected action. And in fact, that's explicitly what the petitioners demand be done. They say that transportation should be considered as a connected action. The title of the very section in the ER, section 4.2.4.1, is titled Connected Transportation Practice, for example. And so that's how it's analyzed, because it is not part of the proposed action, but in fact, it could be reasonably foreseeable, and so it's analyzed as a connected action exactly.
What you've applied for is a materials license. Is it possible by NRC regulations to obtain a material license that both authorizes you possession of the material and transportation of that material to your site?
Your Honor, I believe those would have to be two separate licenses. The application here is for a Part 72 license. Transportation route approval happens under Part 71 licensing criteria.
Now let me ask the joint petitioners, do you know of any way that NRC rules allow this licensing action to also authorize transportation?
What I know is that the, can you hear me?
Yes.
Not too good.
What I know is that the NRC regs don't constrict NEPA. NEPA predominates when there's conflict with NRC regulations, and that the scope of the project must be addressed in the NEPA documents. And to conclude, we believe the scope of the project includes, pardon me if I butchered the pronunciation, but the sine qua non, without which element the CISF cannot exist without transportation. And the entirety of the project thus includes transportation.
Strictly speaking, though, at this point, we're talking about compliance with Part 51, not compliance with the statutory mandate of NEPA, which will ultimately be the staff's responsibility.
Yes.
They're very similar, perhaps identical, but technically at this point, we're talking about compliance with NRC regulations, not compliance with the statute.
But it is the burden of the public interveners to raise the issue at the very earliest.
Correct.
Contention 2 concerning the start clean, stay clean policy. Question for the applicant again. Joint petitioners claim that aggressive implementation of this policy will mean that problematic canisters will accumulate at reactor sites. Do you consider this to be an inevitable consequence of your start clean, stay clean policy? Will you often reject casts?
No, Your Honor. I believe the parties misrepresent, joint petitioners misrepresent the start clean, stay clean policy. It's the same as described in the whole proceedings. General philosophy that all parties along the loading, transportation, and storage route will comply with quality assurance program and NRC regulations. The fuel that the canisters that the applicant will take are outlined in our application. There's no reason to believe that there's any cherry picking involved in that. I mean, applicants, joint petitioners have provided zero indications of any type of task that would somehow be left abandoned.
Do you have any comment on that?
I'm not sure what you're asking me to comment on.
Well, the applicant is essentially saying that's not a policy that's going to be leaving some spent fuel behind. It's an infrequent, quality control. Do you have anything to add to your, that isn't in the petition already? Well, I shouldn't ask that.
Possibly not. But
Any reinterpretation of what you've put in the application? Clarification.
I think that in effect, there will be a process of cherry picking because quality control requirements at the reactor sites are going to certainly exert a limiting effect on what are acceptable canisters for shipments. That becomes really problematic, but in any event, if during transit, contamination or leakage or breach or some type of malfunction is noted in the canister, there will certainly be a time, which may be a significant period of time, it's not really amply discussed, during which canisters will sit at the site. And because of the difficulties of their design, there may be problems in accurately diagnosing what the technical problem is, which may cause further delays. Speculation built upon speculation, but the problem is I don't see in the application, I don't see an ample discussion of risk, of quality control that happens at the site once there is a problem. Don't see site safety procedures in the event that there is a serious ongoing problem that requires a little bit more, perhaps having a dry transfer system for remediation or something like that.
Moving on to contention 11, having to do with no dry transfer system. Question for applicant. On page 119 of the petition, the petitioner's claim, emergency response plan for the CISF contains no provisions for emissions mitigations, i.e. reduction of emissions or releases to the surrounding environment of radiation and or radioactive material from SNF as a result of damage to SNF assemblies and or SNF containers. Is it true that if you detect leakage from some container that you have no means of handling it?
No, Your Honor. I'll have to look at the exact section of the environmental report. Give me a minute. If there is discussion of that. I would particularly, and also in the SAR, Chapter 7.2, the discussion of confinement, if there's any events identified, particularly upon receipt, there's a corrective action program, evaluate NRC, there's provisions for isolation, so we do have provisions for addressing those issues.
If you put a canister out on the pad and it's been sitting out there and after a few years, for some reason, degradation occurs and it starts to leak, do you have some means of mitigating that leakage?
It would be entered, it would be reviewed accordingly, addressed with the corrective action program, coordinated with NRC, and it is discussed in the application. The precise means of dealing with it would have to be based on the actual situation. But there are ways of isolating, including putting it back into a transport line.
Much of this contention appears to be based upon Dr. Gordon Thompson's assertion that, quote, it is likely that some spent nuclear fuel assemblies and/or spent nuclear fuel containers would be damaged at the site as a result of 1, accident, 2, attack, and/or 3, slow degradation. Now, is this opinion of his consistent with the evaluations in the SAR?
No, Your Honor. The SAR discusses, there's no degradation mechanisms for the life of casks. Once the casks are renewed, there has to be aging management programs. There are license conditions requiring the aging management program.
On page 125 of the petition regarding the opinion of Dr. Gordon Thompson, petitioners state, quote, he foresees that likely modes of attack would include initiation of a cask fire involving sustained burning in air of the zircaloy cladding of spent nuclear fuel. Within your storage system, is the zircaloy clad normally exposed to air?
No, Your Honor. All the casks are welded, sealed, and are in an inert environment.
Okay, so there's no normal circumstances in which air would come in contact with the clad?
And unless my experts behind correct me and shake their head, my answer is no.
Judge Arnold, I'd like to point out one thing, and that is that in their application, WCS essentially says that they see no return incentive problem because they never allow problematic casks to come to WCS in the first place. Now, today, they're admitting that, yeah, there could be some problems, and here's our answer to it, and we would consult with the NRC, and we would do this or that, and we're not sure what specific remediation or other types of protective steps we take. I think WCS has created their own material problem in conflict with their own operation.
Thank you.
Thank you, Judge Arnold. Judge DeCouros.
Yeah, some of my questions got answered, so that's good. The safety analysis report specifically says that greater than Class C waste that's shipped to the facility will only be in solid form. Is that correct?
Your Honor, in my 30-plus years of working with nuclear field, I have only known of storage of greater than Class C in a dry cask in solid form. So, but I believe my colleague wants to address that.
Okay, well, I think you just answered my next question. Is there any greater than Class C that's in liquid form? You're saying there isn't?
The proposed, Judge DeCouros, the proposed license specifies the form only so.
Right, and it excludes liquid form. And so I was asking a follow-up question was, is there such a thing as greater than Class C liquid waste at the facilities, at the reactor?
Your Honor, if I'm not aware of anything, any highly radioactive liquid waste at reactors tends to be run through resins and it turns into waste that's disposed of elsewhere. So unless there's there might be some Department of Energy type waste that's processed, but I'm not aware of anything from a commercial nuclear plant on liquid greater than Class C waste.
So the likelihood that there would be greater than Class C liquid waste stranded at the reactors is not viable?
Of the currently decommissioned sites, which the reactors that are knocked down, greater than Class C waste is currently stored on the SFC pads. It is all in solid form.
Does staff have any comment on that at all?
This staff is not aware of any greater than Class C waste.
I just want to make sure that ISP will not be associated at all with what goes on at the reactor sites in terms of their preparation of these canisters for shipment?
That's my understanding, Your Honor. I mean, these sites are responsible for the loading, the quality assurance, and conformance with the certificates of compliance. And the applicant is not involved with those processes. They will, of course, review the quality assurance records, all the records that are required to ensure the contents meets the requirements of the COC. And also, anyone who packs fuel into a dry storage canister will have to meet the Department of Energy standard contract for record-keeping requirements. And I imagine ISP will also review those records. But it'll be a record review and not anything to do with the actual packing.
So there won't be like an on-site inspector at any of these sites at all, right?
It's not my understanding that's during the loading process, no, Your Honor. The loading process is extremely strictly controlled and also observed by NRC during dry runs and quality assurance, highly controlled evolution.
Judge Tracouris, if I may supplement that answer, I think that the fact that WCS is a partner with a firm called North Star that has entered into arrangements at Vermont Yankee for the readying and transport of material to WCS. It looks to me as though WCS may be wading into that field.
Can you speak a little louder, please?
Yes, sorry. It seems to me that WCS may be wading into the tier of actually being much more involved from a proprietary standpoint in the preparation and transport of gas.
Your Honor, WCS, again, is not the applicant here. It's Interim Storage Partners. To the extent that there's certain different commercial entities that have combined to conduct decommissioning of the utilities, that is not part of this application, not the applicant here.
The staff has indicated, let's see, I think it's in the answer to the don't wait, the joint petitioner's petition indicates, I think it's on page 21, 20 to 22. In other words, even if the application does contemplate some canisters may not meet the criteria of this license, that does not demonstrate why it is likely the canisters will not meet NRC regulations, that licensees cannot bring these canisters into compliance, or that oversight of those canisters entails significant environmental impacts. So, do I read? Why don't you just let me know what you meant by that?
Yes, Your Honor. Specifically, I think we have a reference on that on the census to the Commission's decisions in private fuel storage, COI 04-4 and COI 04-22. And those issues, those cases stand for the proposition that will allow some sort of risk of or a violation of Part 71 associated with transportation and sparkling signaling, that there need to be facts alleged that would provide a plausible scenario or alleged QA deficiencies at individual sites as to why it's likely that that would occur.
All right. I think all of my other questions have been answered.
Anything further, Judge Arnold?
No.
If I may, I'd like to make a couple of comments. I'd like to respond to the ISP affiliation or non-affiliation with North Star. The fact is, these are interlocking corporations. It's difficult for me to imagine that North Star would not, in some official business way, have to be in contact and communication with the WCS site in terms of coordinating the transport delivery. I think that now, to hear now that there's simply no relationship with relevance to this application is very difficult.
Do you have any contention that addresses that issue?
No, insofar as we were talking about the other thing that I want to make a comment on, yes, the DTS, the lack of dry transfer system is of considerable concern. I would like to explain my mathematics as to my references to possibly 30,000 different shipments. This will be my last comment, so I'll keep it crisp. Robert Alvarez, we cite him at pages 70 and 121 of our original petition as noting that the transport, the TAD canister policy enunciated by DOE suggests that there may be overall as many as a total of 80,000 canisters that would, the fuel basically would be broken into smaller quantities at some point, either the reactor site or the CISF site. Working backwards from a total of 80,000 and apportioning WCS's portion as 40% of a rough 100,000 MTU total, you get 40,000 that either comes as 3,000 shipments, not 500, as is suggested in WCS's own application, or you end up with 80,000 shipments, 40% of which, the 40% going to WCS would total 32,000 in some form or fashion. Either 32,000 shipments coming from the reactor customers they develop, or at the CISF in some way, you would have to break the fuel quantities down into 32,000 canisters. I think it's a very reasonable, foreseeable, predictable number. And I repeat, this is a big problem that no one is addressing in the application in any fashion. And it bespeaks the whole difficulty that the petitioners have with the denial of any need until 2125 or so to even have a DTS system around. There'll have to be swap outs of whatever storage units are used. There will have to be, there may be, I think we finally know today for sure that there's some conceived possibility that something just might go wrong, even in the first 100 years, where DTS might be a handy thing to have. The claim that was made earlier when Mr. Taylor was up here, that nuclear waste will only travel in dedicated trains. The problem is...
People can't hear you.
I'm sorry, my apologies. The claim that the voluntary offer of the company, of the applicant, that they will only transport in dedicated trains, number one, is not going to be enforceable because it's not a requirement. Number two, I think we're learning a lot coming to Midland, that West Texas is, for some time to come, and maybe a very significant time to come, be the site of the most enormous petroleum and gas development on the face of the planet. That includes Andrews County, it includes the immediate vicinity of Eunice and the actual CISF site. There, in looking at the railroad maps up close, I've noticed that there are several intersections with in very heavy trafficked, otherwise rural-seeming oil patch land, of oil trucks by the thousands, of oil trains, certainly in large numbers. This is the wrong place for this very partially developed, half-baked idea. Is there other questions on that?
Thank you, Mr. Lodge.
Thank you.
Mr. I. All right, I do have a few questions for you. I think, as I've mentioned a couple times, I looked at the declarations that have been submitted by Mr. Taylor, Mr. Tommy Taylor, and Mr. Boyd. The declaration of Mr. Taylor is on behalf of Fasken, actually Fasken Management, I guess, which is a petitioner. And in addition, his declaration, Mr. Taylor's declaration, supports Fasken's representation in the Permian Basin Land and Royalty Owners Association. And then in addition, there is a declaration from Mr. Boyd, who is individually a member of the Permian Basin Association. I'm familiar, I remember the declaration of Mr. Taylor in the Holtec case, where he represented that he had to go in the area of the proposed facility to engage in work for his employer. It's a little less clear to me from the declaration. It admits of that possibility, but I don't think says it quite as explicitly as was said in the declaration in Holtec. And so my first question is really what duties, employment duties or personal reasons take Mr. Taylor to the area of the proposed facility, and how often does he go there?
As Mr. Taylor says in his declaration, he says that his employment duties and personal reasons require him to travel and to spend time in the area of the proposed CISF. Mr. Taylor is an upper management person for Fasken. He's an expert in drilling, he's an engineer. He oversees and is involved in various of the Fasken activities, really from start to finish of their production. That requires him to go to the various sites where Fasken is engaged in exploration and extraction, and make sure that the operations are going consistent with the company's expectations. The frequency that he goes there is somewhat variable. It depends on the nature of the activity that's going on and whether there's a particular need for him to be there. However, it's not unusual for him to go dozens of times during the course of a year to a particular site, and it may even be more than that. Let me clarify one thing. The particular highway that runs closest to the WCF, to the ISP site, has been under some reconstruction, rebuilding due to very heavy oil and gas activity on it, and that has recently caused Mr. Taylor to have to take a detour. So recently, he has not used that particular highway as frequently, but once it's back in a useful fashion, he would be using it again. But historically, it's not unusual for him to be in the area of the ISP site dozens of times in the course of a year.
But his contacts with the site would involve more than merely using the road, I take it. You're saying that he would go to facilities, Fasken facilities that are quite close to the site in that area, and he would get out and do things? Or does he just drive on the highway?
Well, really both, I think is fair to say, because Fasken's closest oil and gas facility currently to the ISP site is 18 miles. 18 miles from the ISP proposed site. So certainly, he goes that close on a regular basis to see Fasken's operations. And but one has to remember that he has to go to also the New Mexico holdings of Fasken, which require him to go, essentially in the immediate vicinity of the proposed facility. And it's also not unusual that Mr. Taylor is called upon to do site evaluations to determine whether a particular activity ought to go forward, which requires more than just driving. It requires him to do some, I guess you can call them general sort of field study.
Yeah, but the 18-mile distant location, that is not like his office where he is on a regular basis. He's there sporadically. Is that fair to say?
It is fair to say that that is not his office. And the frequency of him visiting those, I think, again, is dependent upon the operations and the nature of what may be going on with them on a day-to-day basis.
Right. And he speaks in his declaration of being familiar with other employees who go to the area of the proposed facility. But I take it no Fasken operation is closer than 18 miles, is that correct?
It's, the closest Fasken facility is 18 miles.
Is 18 miles. And so these other employees would either be 18 miles away from time to time, or they might be using highways that go closer than that. Is that?
I would agree with both of them.
Okay. Let me ask you a little bit about Mr. Boyd's declaration. We talked about the size of the ranch, which still amazingly impresses me. 137,599 acres. We said yesterday that's about 10 Manhattan Islands. A corner of that ranch is 4 miles away from the proposed facility. And I know Mr. Boyd, he owns part of the ranch, he ranches the ranch, but part of it he leases. But how much time would he personally be spending in the corner of this 10 Manhattan Island ranch that is near the proposed facility?
Hard to say. I mean, again, it's contingent on the needs of his operations and the requirement that he be there to be a part of those. But I would add that in a more intimate way, the railroad, the New Mexico-Texas Railroad, that is proposed to bring waste to the ISP site for 5.5 miles runs through his ranch. He uses the crossing of that, to get across that railroad to do his various ranching operations. So it's not quite as remote as just talking about the relationship of the 4 mile point, because this railroad crosses his property. He uses the crossings to get it across the railroad, and that gives him a special kind of relationship to the ISP facility.
A question for the applicant. Is there any uncertainty that this railroad line would be used for the transportation of the waste? Is that pretty clear?
I certainly wouldn't say it's a certainty. No transportation routes have been identified as certain to be used here. Speculative routes, bounding routes, representative routes are presented in the application for NEPA analysis purposes. But again, no specific customers have been identified, and transportation infrastructure certainly could change between now and the time that actual transportation happens. So,
But as of today, given how close we are at this point, I can understand that rails, perhaps in Michigan, might not be decided yet, or East. But this close to the proposed facility, is there another rail route that would not go through the Fasken property that might be an option as of today? Or is this really the only realistic option?
I may confer for a moment.
Just for clarity of the record, it's Boyd property, not Fasken property.
I'm sorry, the Boyd, yeah. Through the what's the name of the
Frying Pan Ranch.
Frying Pan Ranch.
So the spur to the current WCS site does connect to the rail line that I believe council is referring to, and is used today for deliveries. It's foreseeable that route would be used.
Okay, thank you. And a question from staff. The staff would urge us to find standing, or at least not oppose standing, both for Fasken, the company, and for the Permian Basin group. And I'm curious whether, I suppose, well, you must have found the Taylor Declaration persuasive, because there's no other source of a representative for Fasken. I guess both Mr. Taylor and through Fasken, or Fasken through Mr. Taylor, and Mr. Boyd as an individual member, both are representative of the Permian Basin. Could you tell us whether you found both those affidavits persuasive or whether you relied on one? What was the staff's position on that?
Your Honor, in particular, the affidavit by Mr. Boyd would be the one we rely on primarily.
Primarily, okay. Did you rely in part on the Taylor Declaration? Or did you rely entirely on the Boyd Declaration?
Entirely on the Boyd Declaration.
Entirely, thank you. I think that's still my question. You may have some more in the area, Judge Arnold.
No, you have it.
Any other questions?
Not on standing.
No, any other questions?
Oh, of course.
Of course.
And again, if this goes to petitions 2 or 4, I'd like to request that my colleagues involved in be able to respond to those.
Contenders 2 and 4.
2 and 4, yes, sir.
Let's see. So you would be 3 and 5.
1, 3, and 5.
1, 3, and 5. No questions on one. No.
Oh, if I can interrupt you, I sort through this. If you're relying totally on the Boyd Declaration, this is a question directed to the NRC staff, that would go to the Permian Basin Group, but that does not go to Fasken Management or Fasken, because only the Taylor Declaration can support that standing. Am I wrong?
No, Your Honor, that's correct.
So you were opposing the standing of Fasken, but not the standing of the Permian Basin, who we're calling Fasken. But is that clear in your plea? I don't think it is.
Your Honor, you may not have in those
That's
words.
clear. Your position today is that the Permian Basin Organization, through its individual member, Mr. Boyd, has standing, but that Fasken itself does not have standing.
That is correct.
Thank you.
Your Honor, may I comment on
You
that?
may comment on that. That's kind of new.
It is new. It is quite new. And number one, it disregards the relative proximity of Fasken's facilities, 18 miles, from the ISP facility, which comes within the zone that is generally considered as being supported standing.
But no one resides there, and possibly there's not even an office there where people work 8 hours a day, 5 days a week.
True, but the economic impact of diminished value of that property as a result of the ISP facility, its operation, would also provide a basis for standing. And it's, if you read staff's response to their answer to the petition, they don't differentiate. And so for them to do so now without explaining away the facts that we have laid out in the petition and in Mr. Taylor's affidavit leaves us wondering precisely exactly how they arrived at the conclusion they did today.
I agree with you, sir.
Thank you.
But I'm sorry, we should let the staff respond to that.
Your Honor, I mean, the fundamental distinction is that 18 miles is outside of the 17 miles that have been found in the previous NRC cases. That being said, the staff would not see it as abuse of discretion to lower legal error for standing to be found for 18 miles versus 17 miles.
Okay, but your position, as I understood it 10 minutes ago, is the same as now. That you have concluded, on further thought perhaps, that Fasken Management, Fasken, does not have standing, because your only reliance on that would be the Taylor Declaration. You can't use the Boyd Declaration for that. He's not associated with Fasken. So Fasken does not have standing, in your view.
Yes, sir.
Okay, but you continue to believe, based on the Boyd Declaration, that the Permian Basin Group has standing, organization has standing.
Yes.
We should probably change the name of the combined group, but that's their position, and we understand that's just the staff's position.
One thing I would comment on, Your Honor, is that the 17-mile perimeter range, I believe the case law would reflect that this is, the determinations are on a case-by-case basis.
Right.
And in that regard, it seems to us that if we have a strict adherence to 17 miles and exclude something at 18 miles, it might appear as if there's an attempt to just be far too attenuated in determination.
Now, 18 miles was, as we talked earlier, an NEI case in the DC Circuit. None of them was deemed to be sufficient. But they were talking about residences. I mean, I think there's some balancing. There's one case, I forget where it was, in Connecticut or somewhere, where 10 miles was considered sufficient where someone had a second home. So they spent substantial time there, but they didn't live there. And so there seems to be some balancing in the distances. But at any rate, we have the staff's position. I'm glad we fleshed out that it's changed. And so we are aware of that.
I would point out that the facility in question, the 18-mile point, is one that does require some employees fastened to be at some portion of each day for monitoring and make sure that the operations are going consistent with your expectations. So there is a regular daily presence of fasting at that facility.
Okay. All right. Well, thank you. I'm sorry to.
Your Honor, just if I may, just ask for a point of clarification from the board. Are we taking new evidence as to standing here, or I just
I was waiting for you to comment on that because as I said yesterday, we are not bringing in these declarants and having an evidentiary hearing based on the declarations. We are taking the representations of counsel to the extent that they may appropriately flush out the declarations. And we'll have to look at those, at that fleshing out as we read the transcript and decide what we may permissibly consider. I take it you would object to anything that we shouldn't permissibly consider, and we're aware of that position. Thank you. Thank you. Judge Arnold.
For Mr. Rai, I have a couple of questions on contention 5. Can you cite to any specific information provided in the ER concerning either the Dunes sagebrush lizard or the lesser prairie chicken for which you have provided actual evidence that is contradictory to what's in the ER?
No, and this contention is really one more of an omission. So that's the basis of that contention. There's an omission of material information rather than contradicting that which is actually been presented.
And every so often, when I go through these petitions, I have a thought which I later wish I never had, and I came across one of those in this contention. Now, early in the petition, when you describe the Permian Basin group, you say that they are specifically organized to oppose waste control specialists. And then I read this about the Permian Basin organization's attempt to repopulate the lesser prairie chicken. And I'm wondering, was that repopulation motivated by them being good citizens and wanting to, repopulate this chicken, or was it because they wanted to make it harder for waste control specialists to use their land?
Well, at the time that it happened, let me make one clarification. To the extent that it was the Permian Basin organization, it was acting strictly through FASTC. So it was really FASTC's participation in the collective efforts of other oil and gas entities, plus the ranching industry, to try to protect the habitat of the lesser prairie chicken, which happened before the ISP
application had materialized. So the answer is no, it wasn't to just be obstructionist and frustrate the efforts of ISP. It was to protect the habitat of the lesser prairie chicken.
Great, thank you very much.
You're welcome.
My other questions are in contention 2 and 4.
We take those up now then.
Yes.
Thank you. Contention 2 has to do with information concerning borings on or near the site. And I'm wondering, how would the SAR containing an enumeration of wells near the site actually affect the suitability of the site?
Well, as our expert indicated, especially for wells that are older, past the 1967, they have integrity issues associated with them. And ISP does not indicate the presence of those wells and how that instability would affect the site, which is a requirement by 72-103, if they are required to investigate the region for unstable geological characteristics. And they do not do that with these unstable geological characteristics, meaning to be abandoned or potential for orphan wells near the site.
Then you're saying there's some sort of seismic activity analysis method that would use actual boring location and characteristics in the evaluation of the stability? Is there a computer program, for instance, that uses his input? There's a hole there. It's so
yes, Your Honor, and that's how we came to that number. And in fact, at this point, that the total number that we provided has actually decreased. So I was going to ask this board, just for clarity, to take administrative notice of that number. We cited 4,947 wells within the 10-mile radius. Now it's actually 4,579. So is it appropriate to ask for administrative notice of this change? Will the board?
We'll note that.
Okay, thank you. And you bring, so yes, there is, and our clients actually refer to it in the declaration from Aaron Packelhofer. They use the Petra software, which is used by the industry to identify the location of these wellheads.
Well, let me just ask applicants, are you aware of methods that use the actual location and characteristics of borings to evaluate seismic stability?
I'm not personally familiar with the software packages that would do that. I think council was referring to software that simply shows the location of wells, not a particular computer code that would analyze those in a geotechnical investigation. But I would note that ISP's geotechnical investigation is included in the application's attachment E, and I'm not sure what they seek to challenge from it. They don't acknowledge that investigation and specifically say here's the defect in the attachment. They just ignore the relevant analysis in the application, as well as the probabilistic seismic hazard evaluation in attachment E.
May I respond? So potential for vibratory ground motion is one of the three characteristics that 72103 requires of the applicant, but it also requires them to look for unstable geological characteristics. It's not just limited to seismicity. It also encompasses the potential presence of unstable geological characteristics. And I will note that I talked about how, especially for wells drilled pre-1967, there are
integrity issues associated with that, mostly because the industry back then had fewer regulations as far as how to properly plug a well and things like that. And if you look at if you break it down, and we'll break it down within a 5-mile radius, there are 645 wells within a 5-mile radius. Of those, 160 were drilled pre-1967. So of these wells, we have 160 within the 5-mile vicinity, and we have no idea what the integrity of those wells are. And it's not our burden is to determine whether these wells have integrity issues. It is the applicant's burden pursuant to 72-103 to determine whether these wells, unstable geological characteristics, will influence the site. Maybe they won't, but it is a requirement by 72-103, and they have not done that.
Thank you. The only other question I have is on contention 4. On page 30 of your petition, you state that the water from the Antler Formation is used as potable water in Midland.
Correct, Your Honor.
I think I noticed that sampling the water at the hotel.
I noticed it in the water fountain out there. So.
On that same page, you inferred that the Antler Formation is exposed in the excavation walls of the WCS low-level rad waste facility. Is that correct?
Correct, Your Honor.
To your knowledge, is the low-level rad waste facility experiencing water intrusion from the Antler Formation?
There is evidence, and we do not discuss this in our petition, so I'm just answering your question, that the low-level site has water contained on the surface of the site that has to be regularly pumped. Whether that, we don't know which formation that water comes from, but yes, there is evidence that shows that there has been water at the low-level site.
Do applicants have anything to say on that?
The joint venture participant, WCS, that runs the low-level waste disposal facility has no indication of groundwater division of the facility, and clearly rainwater collects in the site, and the facility is designed to remove that rainwater.
Good, thank you. I'm done with my questions.
Thank you, Judge Arlen.
Judge Koros.
Yeah, many of mine got covered once again, which is very good. I wanted to ask about the response to the RAI, I think it's 2.2-2, regarding this contention 2. Staff originally had admitted this contention. Now that we have that response to the RAI, are you changing your position on that? I think we discussed this a little bit.
Yes, sir. As we said yesterday, we see this issue now as moved based on the response that there are no working wells on the site.
And do you have any?
May I respond?
Yeah.
Yes, so as mentioned, and as staff just stated, there are no orphan wells found on the site. That may be correct, we don't know that. But the requirements of 72-103 pertain to investigating the region, not just the site, not just 1 mile from the site. And in fact, the new regs indicate that a region is typically 5 miles. It could be more, it could be less, but if we look to the new regs, let me just look at my notes here real quick and cite it for you. The new regs talk about vicinities and applicants needing to identify nearby industrial activity within 5 miles and identify any potential hazards to an ISC from activities or materials at facilities that should be discussed. So let's just say it's 5 miles. It's not limited to the site. And if I may just address the RAI response briefly, it's 6 sentences. So the applicant provided 6 sentences that made staff change its position. And if I may just go through the sentences really quick. So first,
discusses that regionally, the CISF is located in the Permian Basin, which is one of the most important petroleum producing regions of the United States. So that doesn't really address the unstable characteristics of the pre-1967 or any other wells that may be improperly plugged. Secondly, however, significant petroleum storage, not wells that may be improperly plugged, is not located within 5 miles. So they're talking about petroleum storage here, not about the existence of 160 wells drilled pre-1967, which could potentially provide or be unstable. So then we go on to their discussion of the dry hole that is immediately in the immediate area of WCISF, but failed to discuss the producing well, which is within 1 mile of their site. So I guess my point here is that the RAI is misleading. It talks about wells on the site, not wells located in the region. And that's kind of our problem with the applicant's analysis. Is one, it doesn't take into account the region. They mostly focus on wells located on site. And also, they focus here in the RAI on petroleum storage, which has nothing to do with the analysis required by 72-103, which requires them to investigate unstable geological characteristics. And one more point. They discuss that if they do find any orphan wells, that they will be properly assessed and remediated. But this implies that this will occur after a license. And a license cannot be issued until the applicant properly investigates unstable geological characteristics as required by 72-103. And to identify an orphan well afterwards would run in the face of those requirements.
Does ISP want to respond to this?
Yeah, just a couple of comments. First, as to potential orphan wells, I would note that if during the construction of the facility an orphan well was discovered, ISP would have an obligation under existing Part 72 regulations to take appropriate action. This is an ongoing compliance issue that's required under the terms of the license and the regulation itself. So if a new hazard is discovered, it must be analyzed and considered. So to the extent that council speculates that something may happen in the future, there's a mechanism for dealing with that imposed by the regulations themselves.
I would agree with that statement, Your Honors, but we're talking about an analysis that needs to occur before a license is granted.
To the extent council believes that there is a duty to excavate everywhere within 10 miles of the site to determine whether some hidden hazard exists, I simply don't see that requirement in Part 72.
I do.
In addition, the RAI NP 2.6.1 also addressed wells in the area. Additionally, again, I would note that the application thoroughly considers induced seismicity from petroleum recovery operations. It's in attachment D to chapter 2 to the SAR. That's a proprietary document that Fasken and PBLRO did not dispute. They don't dispute a single word in that document, and so they haven't disputed the application.
So in their response and opposition to our petition, applicants do indicate that we did not seek admission or access to attachment D. But while that document discusses induced seismicity from horizontal drilling, it does not discuss the potential for abandoned and potential for orphan wells within the vicinity of the site. And if it did, the applicants failed to mention that in their response. And Mr. Lighty discusses section 2.6.1 discussing oil and gas presence within the area. But if I may quote that section, the statement is limited to the applicants stating that drilling for and production of oil and gas are land uses within a few miles of the CISF. And that's it. They don't discuss the presence of any of these unstable geological characteristics that are associated with abandoned orphan wells. So it's a little misleading to say that that section discusses, to the extent required by 72-103, meets that burden.
Your Honor, if I could say, at this point, 72-103 states that the site will be acceptable if the results from on-site foundation geologic investigation, literature review, and regional geological reconnaissance show no unstable geological characteristics, soil stability problems, or potential for vibratory ground erosion. I would highlight in the on-site foundation geological investigation, and when the Michael offer declaration does not indicate how orphan wells off-site could lead to an impact on-site, and because of that, it does not meet the standards in 209F1 for admissibility of the petition without providing exactly the mechanism as to how those off-site wells, orphan wells, may impact the soil stability on the site.
May I quickly address that, Your Honor? So the ISD staff talks about orphan wells, and that is one of the issues. The other issue is the presence of abandoned and temporary plugged wells. And to the extent that these wells have any integrity issues, which can include case collapse or leakage of these wells, that is something that is required to be analyzed by 72-103, and applicants fail to address the presence of the over 160 that were drilled pre-1967.
That's all I have on conclusion 2. With respect to 5, contention 5.
That's Mr. I's contention?
Yes.
Do you have any questions, Judge Garros, about contention 4? Okay. Thank you, Judge.
Yes, there's a statement made in your contention that relevant conservation efforts may be undermined by the proposed facility. What's your basis for that?
It's a common sense basis. You have a big disruptive construction project that requires earth moving, civil engineering, is just by the force of those particular activities has the potential to disrupt the habitat.
All right, you're not trying to say that the habitat of that region is being destroyed or anything like that. This is just construction, noise, and et cetera. That's what your focus is.
It's a prospective disturbance of the habitat. And I might add to that our Douglas, Mr. Packelhofer, does note that the operation of this facility, to the extent that there are radiological impacts to the vicinity, would, per force of logic, impact species that happen to be in the vicinity.
You also say that the applicant does not address ongoing conservation efforts for either the dune, sagebrush, lizard, or lesser prairie chicken, in addition to whether it would interfere with those. when you say ongoing conservation efforts, are you referring then to the conservation that we've been discussing regarding the oil and gas industry efforts? Is that what you're referring to?
It is, Your Honor, and this was all as a result of, I said, collective efforts amongst the oil and gas industry and ranch industry to try to protect its habitats.
All right, so you're saying they didn't comment in the application that this was going on and that they would or wouldn't be affecting it at all? So it's an omission.
Yes, sir.
Okay.
Yes, sir.
Let me just ask an applicant, what's the footprint area of your site?
The actual initial site is, I believe, 332 acres.
332, so that's what compared to the ranch? That's,
I did that on my calculator last time. I think it's .0002.
okay. Given the difference in areas, if you were to really want to affect ecology, would you try to change what Interim Storage Partners is doing or what DK Boyd is doing?
DK Boyd doesn't have to follow the requirements of Tennessee FR Part 72 or Part 50. That's the difference there. Moreover, DK Boyd isn't building a CISF or any other massive facility, to my knowledge. So the answer is, it needs to be focused on the ISP, not DK Boyd.
The board was notified, in both May and June, I can't remember which was right, but one of those notifications indicated that the ER was being updated to list the lesser prairie chicken as under review. Could you comment on the implications of that?
Well, to the extent that it's potentially going to be delisted or taken off of a threatened and endangered list, that it would certainly reflect the current status of the protection of that habitat, that it is now in a satisfactory status to support that particular species' life and continues. But this does not necessarily go to disruption of that habitat during the construction operation of the CISF. So, yes, and when it's under review, it certainly raises the prospect that its status might not change as a result of that particular review. And although I don't know the intricacies of that review at this point, because I don't know that it's actually been made public, the results of the review, but I would anticipate that a comprehensive review would take into account the potential for the presence of a CISF, both in terms of its construction and operation. Or I would think that would be a germane topic for that review to consider.
I might clarify if there's any confusion. The lesser prairie chicken is currently delisted. So the review is whether to list it. It's not under review of whether to keep it on the current list. It is currently delisted.
I agree with that. I mean, it's,
In other words, under review doesn't mean that it may end up on the list?
It will, but I was wanting to clarify. I thought his statement was that it was under review for delisting. That's not.
I may have misspoken.
That's correct.
But of course, the implication of it being under review means there is some effort to determine whether its ongoing status is satisfactory. Given the extensive efforts of Basket and its coalition partners in terms of trying to protect this species, I think that is a prudent thing to do, particularly in light of this proposal to build the CISF in that region.
And whether or not a species is on the endangered species list, does that really matter with respect to the ER and conservation efforts?
Well, to the extent that they do have to take into account impacts on species in the area, I think it is a consideration.
So even if it's not on any list, if it's a subject of conservation efforts in your region, you're saying the ER has to address that?
I think that it's only prudent to do so unless there is some ironclad assurance that the vulnerability of a particular species, let's say the lesser prairie chicken, is not going to be affected in any way, shape, or form by the construction or operation of CISF.
Any comment on that?
Your Honor's question is very good, because the issue is really, the ER thoroughly discusses lesser prairie chicken habitat, the occurrence, or actually the absence of occurrence of any lesser prairie chickens since 2007, and that was only an anecdotal site. So it is thoroughly discussed. And NEPA is not active for it. The idea that there has to be an ironclad prevention of any impact on a species that's not listed, it's no such thing.
Your Honor, I might add that there is a state listed species that also, I think, are germane to this contention as well.
Does staff have any comment on this? All right, that's the end of my question.
Anything further? Mr. Arnold?
Thank you.
Thank you.
All right, well, I think that concludes what we want to do today. I don't see a show of hands of enthusiasm for very short final statements. I think everyone has a very good opportunity to state their positions on what's at issue. The board's job now is to take all of this information, and particularly, of course, as we said yesterday, there are hundreds of pages, literally hundreds of pages of filings on these issues, and they, of course, are also a very important part of what we need to consider to reach a decision. The commission has milestones or goals for our doing that, which we very much try to comply with. We know we ask the parties to comply with deadlines, but we try to comply with our own deadlines. Assuming there are no further filings, our deadline would be 45 days from the day, which I think is August 26th. So we would either have a decision then or have a notice as to when a decision could be expected. In the past, sometimes there have been filings afterwards, after an argument, and we have to make a decision whether that's a reason to postpone the decision or to deal with those other issues separately. But as matters now stand, our target is a decision by August 26th. Really, on behalf of the board, I want to thank all the council, really, for all the petitioners, the applicant, the staff. These have been very helpful presentations. They've been very professional, and they make our job easier. And again, I want to thank the county commissioners and everyone here at the court who's gone out of their way to make this possible, first of all, possible in this facility, and secondly, to make it, at least for us, and I hope for everyone, as easy as possible. Any comments further? No. Judge Arnold? Mr. Burrows? No. Thank you. We stand adjourned.